Welcome to California Virtual Family Law Attorney with founder Linda Garrett.
Welcome to California Virtual Family Law Attorney with founder Linda C. Garrett. With over 20 years of experience practicing family law, Linda and her firm offer a unique blend of traditional representation and unbundled legal services, custom tailored to the needs of the individual. I'm your host, Jon Clemence, and today's episode is Custody and Visitation in Domestic Violence Cases. So, Linda, welcome back to the show.
Thank you very much. And how are you, Jon?
I'm doing pretty good today. How
Okay,
about you?
great. Great. I'm ready to go. Let's go.
All right, let's go. Well, unfortunately we have to talk about a serious topic today in domestic violence and custody. So, not a fun topic, but a necessary one. So my first question is, what steps does a domestic violence survivor need to take to file a restraining order in your state of California?
That's an excellent question. And I like the way you phrased it. What step does a survivor need to take? Well, let's roll back the clock a little bit because they're not considered a survivor yet until they've done a few things. Because, well, to answer your question directly, again, as an attorney, I can go all over the place because this is a huge, huge topic. I just had a trial 2 days ago on domestic violence with a police officer. So the first thing I would say that a person needs to do is to understand it from the court's perspective first. So there are steps they've got to take, but before we even take those steps, understand their request, if they make one, from the judge's perspective. So in family law in California, it's almost always the he said, she said. But here's the rub. If there's children involved, the courts are aware there's a large percentage of parents, especially the mothers, statistically speaking, of course, who are going to make a false claim of domestic violence because they have been told or they read somewhere on the internet that there's California Penal Code 3044, which is known as a rebuttable presumption that if the court grants restraining orders against the other parent, in this example, the father, there's a rebuttable presumption that mother shall have so legal, so physical. So guess what? Anyone who's listening or watching, the court's aware of this. So they know these things, especially when we start seeing in a divorce case, all of a sudden domestic violence as well. So what the person says, I'm a victim, you can tell that's your friends and family and the police, but at the courthouse steps, you have to prove you're a victim. You just can't say you are. So the first things you have to do is have the evidence. And you say, well, how do I get evidence? Nobody saw this. Well, guess what? There is a penal code, and that's Penal Code 633.6. And read that because don't take my advice. I'm not, the person's listening, I'm not their lawyer. But essentially, in a nutshell, it allows an exception to the confidential recording, which we all know you can't record if I don't know. But this is the exception allowed for when the person feels they're in danger, they won't be able to prove it. It's a he said, she said. They can record without the other person knowing, and then use that recording if necessary in court because now they have the proof. So I would say the steps that need to be taken is understanding the court's perspective of how they see these restraining order cases, especially when children are involved. And to have the evidence because it becomes a he said, she said. And if I'm being honest, I have worked, a little backstory on me. I have worked in 10 Bay Area counties in 14 courthouses as of today. And what I have learned is that the judges are not the same. We can have a rubber stamper who just says, yep, granted, all the way to the other side where prove it to me. Nope, that's not enough proof. More proof. Denied. So you get the gamut of those. So you don't know who your judge is. So you've got to have some homework. And so at the end of the day, again, to answer the simpler question, again, I can go on for hours on the subject, but the simple question is be prepared, understand the mindset of a judge, especially if you're a divorcing person, if you've got children, understand the problems the courts see all the time with the he said, she said. And but then when you feel like you're ready or you have to, then that's where you would go to the court and file various documents And so the various documents are a package that most courts have already stapled. So here's your package. But they include documents such as DV stands for domestic violence. So DV form dash 100, 105, 109, 110, 130, and others. But it's a package, and you can get help for free. You can get help with a coach such as myself. You can get an attorney to represent you. But essentially, you want to be able to prepare your case and not have it be the he said, she said, because that's where we get stuck.
The natural question was, okay, so if we're going to send people to the legal code to go read about what they can do. But let's say they decide, okay, I've read the legal code and I think that I want to start recording things. Is that like using your cell phone, or is it like writing things down in a diary, or what would count as, a good, what would be a good idea?
Yeah, that's an excellent question, John. So it's more, so that code protects, so that evidence code again is the 633.6. And that's more when you believe it's actually happening. Like you hear your husband in the other room, or the other person, I should say, yelling, oh, there he goes again. Oh, I'm getting the chills. Let me get my phone and hit the record button and then black it out so he doesn't know it's recording. But it's designed for the knowingness, if you will, that this person's going to be doing what they always do when they get to this point. It's not designed for, let me record all the time, record, and oh, this one's a good one. No, you're now abusing the statute, and you could be actually held. It could be used against you because now you're recording this person without their knowledge, and you're not using it for that specific. It's a very specifically carved out exception with a lot of guardrails that you can only use it for A, B, C. That's it. And if you're not using it for that purpose, then you're not protected, and then it is illegal to record someone without their knowledge. There's a few exceptions, one or two, which I won't get into in this conversation. They should speak to an attorney because this is not advice. This is just general principles to look for. But it also has to be, again, in what they believe is going to be, or is the start of something domestic abuse, violence, etc. And it's got to be fresh. You can't say, well, here's my recording from 10 years ago.
Yeah.
Because the goal is to create evidence to use when you file your DV-100 in court. So now you have your proof, and you can say, I have a recording pursuant to blah, blah, blah. And now the court says, oh, it's not a he said, she said. It's the, oh, okay, this is different. This is different. And as I say that, I get the chills because I wish people would do that, but they don't. I get the call like, did you call the police? No, ma'am. Why did you not call the police? Because I was protecting the father of my children. How many times has he done this? A lot for the last 20 years. How many kids do you have? 5. And you have any proof? No. I get those calls.
That's a hard that's a hard case right there. And I do want to talk about that. Yeah.
Sure.
Because when you're talking about, let's say, a husband and a wife, for example, there's a good chance there are children involved too. And that's a whole other, question.
Yes.
But I'm curious to know, when you have these cases, I guess, in a non-legal sense, just these situations where there's a restraining order or a protective order, how does that influence something like custody and visitation? Like how do you wade through that?
Yeah. So there is a carved out exception. So procedurally, what happens is when someone submits, at least in the counties that I've worked in, is when someone submits their request for restraining orders, it's dropped off. And the clerk says, come back in 24 hours. And because the judge has to read your request and see if it's legitimate or not. And it's not really legitimate as much as what they're saying, whether it's true or not. Like he threw boulders at me and he had a knife thrown. Even if it's all made up, the courts don't care at this point when they file. They just say, okay, because it's signed under penalty of perjury, which means you're not supposed to lie. But we don't care right now. Well, I would say don't care. They're like, we don't have time to know if it's true or not. But for now, we're going to take you at your word. And then depending on what you wrote, the court will do one of 3 things. They will either, the judge who's reading these papers on, let's say today, will say temporarily approved or granted as to all requests, temporarily denied as to all the requests, but more likely they'll see temporarily granted, temporarily, and then the others are going to be addressed later on at an actual formal hearing or trial. But let's just say the court says, yep, for now, dad has to stay away from the kids or I should say party B, be fair. Party B has to stay away from the kids, but the courts will normally have a hearing by statute. It's got to be quick, roughly 20 days from when the issuance of temporary orders, if they're granted. So if they're granted, then if it says dad can't see the kids, dad can't see the kids. But if it doesn't say they're granted as to the children, dad can continue to see the kids, but the communications, there's a box that's checked off on the temporary order that says they must be peaceful communications regarding the children. So the courts will, if that is allowed, then that's what they have to do. And 60% of the time, 70% of the time, party B, the restrained party, is in compliance. And so hopefully it stays that way until the court at a formal hearing or trial will then just determine whether there's restraining orders protecting the children from party B. Only time will tell.
That does make sense. But my follow-up question is, what about the kids? Like, do they get to have a say in it? What if they say, I want to see my parent or not see my parent? Does the court consider their desires and wishes?
Okay, you've asked a very good question. But here's the problem with this question is that we don't know the age of these children. Are they 6 months old? Are they 14? Are they 17? And then also, what is their maturity level? And statistically speaking, because there's always an exception, I need to say that. But statistically, the courts are reluctant to have children have a say. And it's very common. But Ms. Garrett, if you only knew my child really hates his dad, blah, blah, blah. I get that. But the reason they're called children, let's ask ourselves, why are they called children? That's because the law or doctors or somebody decided that before age 18, their brains are not matured enough to make informed decisions. They want cereal for breakfast, lunch, and dinner because they don't have the wherewithal to understand their body needs more nutrition than Captain Crunch, But if you ask a kid at 7 years old, that's all they want, and popcorn. So they don't have the maturity to make the decision that includes understanding the consequences of what they're asking. On top of that, the courts are reluctant to have the children have a say because they can be easily influenced. I actually have a case like that. It's a trial that I'm going to next week, actually, where the father, it's not a domestic violence, but the father wants the 14-year-old girl to move with him to Sacramento. And he'll say, oh, my daughter wants to leave. But we found out, that the daughter was bribed and said, honey, if you move with dad, I'll buy you a car. She gets a car if she moves with him. So the court in this case allowed the daughter to be interviewed, but now we already know what she's going to want to say, right? I want to go with daddy.
Of course.
Why?
Yeah.
A car is waiting for her at his house. And by the way, she can only drive said car when she's at dad's house. So, and again, she doesn't understand that she's walking away from all her friends, the doctors, the pediatrician, the dentist, the extracurriculars of cheerleading, the school, all those things because she wants to go. And this is a true story, to go with dad who's got the car. And there's nobody there except him and his girlfriend. So that's the reason. And then the third reason, if I'm keeping track here, is then that the guilt involved and the consequences if the child says, putting that case aside, we're now done with this case, the child does testify or does state an opinion. Now, let's say the child says, I want to stay with mommy. I like it being at mommy's house. So then what happens a lot of times, this actually does happen. Dad says, well, you don't love me. How can you do that for all the things I ever did for you? I will forever be torn by what you did. And now the kid gets to suffer. I get emotional, suffers the consequence of being honest. And so we have another form of emotional abuse, bringing the child through the system. So when my clients ask me, get emotional, sorry. When they ask me, should I have the child speak? I'm the first person to say no. And but Ms. Garrett, you don't understand. I said, no, I do understand. It's that you don't understand all the other things as a lawyer with 24 years as of this year, all the repercussions are going to come from this, what you think is a simple request. And I had a personal friend whose children, who were teenagers, 3 boys, who were forced to testify in open court against their mother. And that has hurt this family forever now. They will never be the same because of the wounds that have been caused by the kids being forced to testify, and dad forced them to testify in open court. So, see, I can go
Yeah.
on. So,
Yeah, I mean,
simple question, not a simple answer.
yeah, not a simple answer. Yeah, I
Mhm.
mean, I have a 16-year-old and a 13-year-old, so I completely understand they're still forming. They're not quite ready to make major life decisions yet because I experience that every day. So that
Mhm.
makes a lot of sense to me.
Yeah.
And then, yeah, and then I think we've talked before about how if you're not putting your children first in all of these issues, you're doing something wrong. Like, so to hear these stories it hurts your heart, to hear someone use that. Do you think there's any better ways to kind of mitigate some of the I know that you personally in your role are trying to mitigate and some of these issues. Are there ways the court system could better help these kids who are experiencing trauma in this situation?
The courts, no. And here's why, because the courts are not babysitters. The courts are not therapists. They're not doctors. They're kind of the court of last resort, literally, because that means that by the time you got to court, it's because you've not been able to resolve these things on your own. So then the judge becomes King Saul and says, well, I'm going to decide. I don't know you guys. I don't know your history. I don't even want to know your history. Here's what I'm going to do. So they don't care. So they're not going to fix anything. So that's why you'll see people like Angelina Jolie and Brad Pitt years later still fighting over custody because the judge is there. I'm not here to fix you guys. You guys made this mess. Tired of seeing you guys, to be quite honest with you, but here we are. So they're not going to help. Instead, here's what I do. So I get that phone call, Miss Garrett, I want to file domestic violence orders against my husband or my wife. Okay. And so I always start, and people don't like this. They say, so I want to hire you. And I said, I'm not for sale. There's not a for sale sign on me. I will not represent you or help you until I believe 2 things. You do have a domestic violence case and you're doing it for the right reasons. And it's not, you can't avoid, you don't have a choice. And I've come to find out a lot of my callers, I say it with love. If you're one of my former clients watching this later, that not always does the person come in with the right motives. And
Yeah.
sometimes the facts are not that. So I have a case that I'm coaching on where essentially the goal is for the mother, she's strategizing with her attorney to put restraining orders in place so that she can get that presumption of Family Code 3044 to move to another county and then live in that county where her parents can help with the kids. And then she can travel all over the country for work. And so, with that said, there's a strategy going on behind the scenes. And so, if I'm helping the father, I'm going to say, yes, you need assistance, representation, because you're being set up for the wrong reasons. But now, let's just say it's the mother reaching out to me, telling me these things, and I'd be essentially talking her out of the restraining orders because the examples she gives are 1 or 2 texts that he was mad. Now, imagine how many couples, Jon, are mad and raise their voice to the other parent or partner near the end of a divorce or near the end of a marriage. At that point, they're all constantly fighting about, why did you leave the toilet seat up again, Jon? I'm tired of you leaving the toilet seat up. Sorry, didn't do it. Yes, you did. It's on purpose. I know it. You hate me. Guess what? You texted her. Well, that's what you get for doing this. Oh, there's my exhibit A. He just threatened me, Your Honor, that he's going to keep the seat up all the time. That was essentially kind of her exhibit. He threatened me, Your Honor. He was going to walk into this house, our bedroom that I locked, that he couldn't come in, or the house. And so, again, I always tell people if they want to work with me, that I'm going to vet them. Like just as they need to vet an attorney, I'm going to vet them because I don't have the emotional capacity, because I do care, to just take it. I will never do it just for the money, ever. Never have, never will. Where if I'm representing you, it's because you need it and there's no way around it. But in other cases, the people who say I need it, No, you guys just have to stay away from each other. That's what the divorce is for. If John moves out or you sell the house, there's no toilet seat to put down, right? Like, yeah. Problem solved? Yes. Ooh, yes, Miss Garrett. So I'm like, all right, there we go. And by the way, John and his wife saved money because they didn't have to go through this trial of DV and deal with total strangers deciding when you can see your kids. So DV, domestic violence cases are very serious. As you can see, I know that, but I also know that there's a lot of them that are not legitimate, and there's a percentage that are not for the right reasons.
Yeah. Well,
Mm.
it's a great way to kind of wrap up this subject, which again, it's not the easiest subject in the world to talk about, but it's super important. So thank you so much, Linda, for just coming on today and sharing.
Of course. Thank you.
Yeah. And for the listeners, yeah, thank you for tuning into California Virtual Family Law Attorney with founder Linda C. Garrett. To connect with Linda and her team, head to lindacgarrettlaw.com. And as always, be sure to like, subscribe, and leave a review, and we'll see you next time.
Bye, John. Bye, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.